All right. Good afternoon now, everyone. You have come to the Children's Law section of the State Bar of New Mexico New Knowledge, Legal Role Differences in JQ Cases, Tips and Tricks as you navigate Respondent's Attorney, Youth Attorney, and GAL. My name is Shasta Inman, for those of you who don't know me, most of you do, and I am joined this morning, or this afternoon, by Twyla Hoon. We are recording this session for later viewing and use. This is not certified for continuing legal education credit. If you have any questions, you should be able to, in the chat, chat directly to the host, that's me. So any questions that you have during the course of the program, just pop it in the chat, and we will address it during the question and answer session at the end of the program. And if you have any technical difficulties, you can also put those messages in the chat. I'm going to share my screen now so y'all can see the PowerPoint. Of course, I have too many windows. There we go. Go ahead and tell us more about yourself, Twyla.
All right. Good afternoon, everyone. I'm Twyla Hoon. And since about 2008, I've been in and out of working with respondent cases, delinquency cases, as well as criminal. Prior to 2008, mostly district attorney, prosecution experience, and some civil law. But since 2008, a lot of my focus has been on this type of law. I've held roles as the guardian ad litem, the youth attorney, represented respondents, and prosecuted, of course, previously in delinquency cases, and worked as the attorney for the youth in cases since then. I usually move around more, so this is really hard to stay put.
That's excellent. I have been an attorney practicing in New Mexico since the beginning of 2017. I started out as a guardian ad litem and youth attorney with Pegasus in the 2nd Judicial District and the 7th for Torrance and Socorro counties. I am now with Advocacy Inc. and have also expanded my contract to do all 3 roles in the 13th Valencia County, as well as still 7th Judicial District, Torrance and Socorro, and the lone Catherine County cases that sometimes pop in. Prior to coming to New Mexico and practicing as an attorney, I spent 10 months as a juvenile court law clerk in Arizona, working with a judge and helping him write probably a dozen termination of parental rights orders while I was with him. Our agenda today, we're going to go over representation differences, client communication and interactions, and how tips and tricks for navigating those throughout the roles, some attorney ethics questions and collegiality points, and some time management. And then, like I said, we will be reviewing questions at the end. We're going to be referencing a lot of resources today, including the Administrative Office of the Court's performance standards, which have been adopted and promulgated by the New Mexico Supreme Court. So all of the links are there, and I will also send this PowerPoint out to everyone after the session. I have also presented a link to the Corinne Wolf Child Welfare Handbook, and there's also periodic updates that are not part of that big PDF, but are also available at the Corinne Wolf website.
So whenever we're speaking about abuse neglect cases, there's obviously a lot of players in the case. We can't go into everything, so we're focusing just on representation as it exchanges between representing the parent, representing the youth, or representing the child. Except as otherwise provided, the child is entitled to the same basic rights as an adult. Parents, guardians, and custodians each get assigned an attorney if indigent or as in the interest of justice. Children under 14, of course, get a guardian ad litem. Youth 14 and older get a youth attorney. The interesting thing is frequently when we're talking about representation of youth and representation of parents in abuse neglect cases, a lot of the roles are actually in some ways similar, unlike when you're the guardian ad litem and you're speaking out for the best interest of the child. So a respondent attorney is going to, of course, zealously represent the respondent's expressed interests. It's a client-directed representation. I don't get to say what I think is in the client's best interest. I get to represent to the court what the client wants represented. Now, as part of my representation, of course, I am behind the scenes going to make sure to try and get my client to understand not always what they're wanting to do might be the best for their case. But at the end of the day, if they want me to represent their opinion that they're ready for their child to be returned home right this instant, even though I know that the court is not going to see it in the same light, that will be what I argue for. The rules of professional conduct, of course, are always applicable. So I cannot elicit perjury. I cannot do frivolous motions, but we do have to balance out our clients' expressed wishes and make sure they understand the limitations placed upon us by the rules. Let's see. Having a hard time tracking the slideshow and my voice. In the basic rights first slide, of course, CYFD employees shall be trained to do their legal duty to protect rights. As respondent attorneys, as youth attorneys, as GAL, though, of course, we're independent of the department and we have an equal duty to protect our clients' rights and to argue when situations are arising that our clients' rights are not being protected, even though the department ultimately should also be protecting those rights. It falls to us to articulate those rights for the court. Confidentiality, of course, applies in all representations, but when representing a respondent, it can get rather tricky because on the one hand, there's a lot of information sharing back and forth, a lot of reports that the department's getting and then should be sharing with the parties. But oftentimes clients will have their own information. And so you have to make sure you have a method of keeping that separate, whether it is verbally given to you or paper given to you. I frequently have a note section that just talks about what my client and I are discussing separate from what the department may be asking for them to participate in. For example, if they want to do extra counseling, we have to discuss whether or not that's something we're going to put out there, have them sign a release, have them allow the department to receive the reports on it, and about the fact that, it's not going to necessarily be credited to their case if the department is not able to get those releases of information to verify.
I think we go into some additional examples and details later on in the slideshow.
I think so.
So, youth attorney, which is beginning at the child's 14th birthday. So if the case is started and the person is already 14, they are assigned a youth attorney, or if they are in custody at the time that they turn 14, that will transition to a youth attorney. And we'll go into a little bit more detail on that exact transition later on in the slideshow. But the most important thing to note about being a youth attorney, and this was also mentioned in the basic rights slide, section 32A for 10, the youth attorney role is basically the exact same as a respondent's attorney role, except you're representing a teenager. So you have to zealously represent the youth's expressed interests. It is client directed. You have to protect the youth's expressed cultural needs. And you have to follow all of those rules of professional conduct and confidentiality in the Children's Code, just like you would as a respondent's attorney. Section 32A.410F specifically says that the court shall assure the child's attorney zealously represents the child. There is no specific difference in the practice standards put out by the AOC and the Supreme Court between a respondent attorney and a youth attorney. There's some very minor differences, which I just want to briefly go through here. So I literally went as a fine-tooth comb between the practice standards for the RA compared to the YA. So if you look at them, there's some formatting differences, but otherwise they're basically the same. The youth attorney practice standards indicate you have to give proper notice to the youth and let them know that they have the right to be present at the hearing. That's not in the RA standards, but it's really important for an RA as well. There's a couple of differences in logistics and requirements for appeals, given that the youth attorney is not really the accused, or the youth is not really the accused in these matters, whereas the respondent has those appeal rights. Included in the respondent attorney practice standards, but not the youth attorney practice standards, is regarding change of venue and staying on. However, that seems to just have been inadvertently left off the youth attorney version, since that same language is expressed in the GAL standards as well. There is also discussion in both the GAL standards and the youth attorney standards regarding what sort of contact those child representators would have after the case is closed. That's not present in the respondent attorney practice standards. There's different examples of what sort of what sort of relief you can request in court and by the judge, and services that CYFD can put in. But those are included, but not limited to lists, so they would really apply to the RA in most cases as well. And then the GAL and the YA standards, but not the RA standards, discuss citizen review board meetings. Other than that, the practice of a respondent's attorney versus a youth attorney is basically identical. There's some differences in how you talk to your clients, and what rights are needing to be protected, but the actual logistics of it and the zealous representation of their expressed interests is the same. Twyla is going to talk some more about those rights differences. Have I muted you? I'm sorry. There you go, Twyla.
Thank you. And actually you didn't. I hit mute to stop my dogs from interrupting you, and it wouldn't let me unmute again. So,
okay.
So it wasn't actually you, it was me, but so. So a lot of the basic practice standards are the same, but the case rights are different. Some of the goals will be different. Abuse neglect cases, protecting the rights and interests of the parent is different than protecting the rights of the youth. As mentioned, the youth is not the accused. The youth is, while they may feel like their rights and the parents are being terminated, ultimately the focus of the case is reunification with the parents or termination of the parents' rights and finding a permanency plan for the child as it goes on. So when we're dealing with the respondent versus the youth, there's a little bit difference as how I'm going to have to advise them. So if the youth wishes to address the court, obviously as the representation of the youth requires talking to the youth about what to represent to the court, being truthful, behavior in front of the court, and everything else. But at the end of the day, that child's statements are not necessarily going to be used against them. Even if I get used to community in my respondent case, representing them by the state, how's it going to be perceived by the court in addressing how they've progressed in their treatment plan? Use immunity protects testimony, but even if the respondent is sworn in before addressing the court, that may not fall under the envelope or the umbrella of testimony as set forth in the use immunity paperwork. So I always have to make sure that my respondents know they need to just assume the department's going to use it against them. They need to be careful how they present themselves to the court, and a little bit more weighing on them. Sorry. I apologize.
We love your puppies, Twyla. And the rules and statutes for use immunity for criminal cases in these, as related to these JQ abuse and neglect cases, they explicitly provide that you can get a use immunity order for a respondent. However, there is an argument that can be made that you can get one for a youth. I successfully had a use immunity order provided for one of my youth clients because he was afraid to, he was objecting to being in custody. He wanted to go home. And so he wanted to testify basically on his parents' behalf. But there was concerns that he could get delinquency charges based on what he might testify on. So I made an argument that it also applied to youth for these same considerations, and the judge did grant that use immunity. It got a little hairy because the youth did not currently have delinquency charges, which is kind of the point, because I didn't want them to bring charges against him. So the DA in that I contacted was not wanting to provide a position because there was not an open case. But regardless, the court did grant my youth the use immunity order. And later he decided he no longer wanted to testify, so it was moot. But at least we had the order to cover ourselves in that case.
And the use immunity can be a useful tool in representing the respondents. I've been debating with myself just making it a standard pleading filing at the beginning of the case, whether I think it applies or not, because I've had some cases where it didn't look like it was a necessary motion merge into a case where it was like, now we need use immunity put into place to protect the respondent. On the other hand, we're not supposed to file frivolous motions, but I think that even if we don't know if it applies per se, I don't think that would fall under frivolous for just asking for use immunity carte blanche on all of the cases. But at the end of the day, the client's position rules. The client directs the method of response that as a respondent attorney I'm going to be handling. An example we have up here, a parent client has severe psychosis, hallucinations, therapist is a lizard wearing a human suit, etc. But their primary expressed interest is having the children return to their care. That is my goal as a parent representation, is to argue and try to get the court to see that the children should be returned to my client. I need to make sure my client understands the reality of the situation behind the scenes, but in court, in public, in expressing my client's opinion, that's what I need to be focusing on. And sometimes it does lead to interesting situations. I've had in a youth case where I'm expressing the client's interest, even though the client wants to be placed somewhere which perhaps the court's not going to see as safe. It's still the argument I need to make because that's where my client wants to be. And it's not my opinion of the best interest of the client, it's what the client is expressing. I can make sure my client knows that I don't think there's any way in heck that it's going to be allowed, but if that's their expressed interest, that's what I will be arguing. Some other examples, parent-client insists on directly addressing the court or testifying at trial. The state, of course, can call my client to testify. There's no ability to invoke the Fifth and refuse to testify on my client's part, but frequently the department does not call my client, but my client wants to testify. I have had clients testify despite the advice given to them about situations that we know are shooting them in the foot in their case, but all I can do is advise the client that it's not wise to go there. If they're gonna go there, there's not much I can do to stop them. If they're being non-responsive to the questions being asked by the state or the guardian ad litem, I can object to non-responsive. I've done that a few times just to try to get my client to get back on page and stop mavericking off into the distance with whatever is on their thought process that day. But if they want to testify, I've got to mitigate the damage and try to put it in the best light possible. Youth client wants to be placed with their cousin. Even, with the state expressing, they just want to, go be a sex worker. They want to run with a biker gang. Doesn't matter. If my client is expressing they want to be placed with a family member, that's what I need to be arguing. Sometimes the other parties may accuse you of not having your client's best interest at heart, etc. But the fact remains is it's not for me to determine what's in my client's best interest. It's to argue my client's expressed interest. Not considering the residential treatment. I've had clients that really think that would be useful on, but if they're not consenting and for example, the youth, they're not petitioning for involuntary treatment, then we're going to stick to the client does not want the treatment. Zealously represent the expressed interest, abide by client's decisions concerning the objective of representation in MRA 16102. I mean, in a nutshell, sometimes you'll make arguments that you don't like. You always have to have candor to the court. It's required also under the rules. You can make sure you express to your client that just because I'm being civil to opposing party does not mean I'm not zealously advocating. But at the end of the day, I'm going to make the argument you're asking me to make.
We have had some comments from the chat that are comments, not questions. So I did think that they're appropriate to jump in right here. So another suggestion regarding having, if the respondent insists on testifying, we have to be really careful to limit the direct testimony that is elicited to protect against the cross-examination, because then you can always object to outside the scope of cross. I know that as a GAL in a case, I have tried really hard to get that respondent to testify outside the scope of direct, and the respondent's attorney was very good at shutting that down very quickly. There's also comments that these examples are very negative, and I think one of the things that Twyla and I wanted to impress upon is the most ridiculous examples are the most memorable examples. So absolutely, our examples definitely go more toward the negative. And you would not, while you are advocating for your client's position, really talk about all of these negative aspects. You would more fully and positively tell the client's story. So that's where the difference is. Yes, the zealously represent the expressed interest and the final objective of the client, but you always have to weave that in a way to best advocate for it. Because the argument that your client necessarily has to support the position that they have might not be a winning argument, but you might be able to come up with an argument that's winning, even if it, to get their final objective, even if it's not the argument they specifically wanted you to make. Is that a fair representation there, Twyla?
I'm sorry?
Is that fair representation?
I think that is fair. I mean, obviously, I'm not going to be the one stating that, my client wants to live with their cousin because they want to run with a motorcycle gang. That was, of course, the state's counter argument. My expressing it to the court, and nothing wrong with expressing it this way, but my client wanted to live with her relatives in the cultural environment that she was comfortable with. The state had, of course, a completely different view of the appropriateness of that cultural environment, but that was the environment that she grew up with. That was the environment she wanted to live with, and she wanted to be around people who understood her and quit trying to basically
micromanage her life.
Yeah.
And for example, for that top example, the argument that you would make as a respondent attorney in that is, does that the severe psychosis, thinking your therapist is a lizard wearing a human suit, that does not impact the safety of the child. Yeah, it might be, in your opinion, as your client's attorney, super weird, but it does not impact that delusion. That psychosis does not impact that ability to keep the children safe. There might be more facts that the department's going to throw in to show that, but that's your argument. That's the quote unquote positive spin that you would take in that case. And then Twyla also mentioned, of course, the two rules of professionalism that are on this slide. 16.303 is candor to the tribunal, so no false evidence, no suborning perjury. And then 16.102, abiding by a client's decisions concerning the objectives of representation. Another good thing to remember as you are consulting with your client in this area is the creed of professionalism for the State Bar of New Mexico. Talks about advising your client that civility and courtesy are not weaknesses, because I've had lots of clients say things like, why are you even talking about a plea offer? Because that's what we have to do, right? They've offered it, I have to talk to them to get the details, and then I have to relay that to you. It's totally your decision whether or not you want to take it, but I have to provide you that information. Do you have anything else you wanted to talk about civility there, Twyla?
No, I mean, I think in a nutshell, everything always has to be balanced out with common sense. I may be facing an opposing counsel that is in reality a good friend of mine. That's not going to change my zealous advocacy for my client, but it may require me to not be civil, but perhaps check my normal chattiness with that person in that setting, simply because depending on what your client is experiencing and perceiving, which I think that's a little bit later on, it can help for you to keep that little bit of common sense removed in the situation, while letting the client know, yes, I'm going to be civil and appropriate. Doesn't mean I'm going to go over, sit down in a chair next to them, sling my arm around them, and whisper in their ear, as another extreme example.
All right, the difference is some more about between youth attorney and guardian ad litem. Obviously, youth attorney begins at the 14th birthday. Guardian ad litem is anyone younger, represents anyone younger than 14. The guardian ad litem, as opposed to the youth attorney and the respondent's attorney, the guardian ad litem shall zealously represent the child's best interests, not their expressed interests. The guardian ad litem still has to present to the court the child's expressed interests, but they are advocating for the best interests. Any party may petition the court for an order to remove a guardian ad litem if the guardian ad litem is unwilling or unable to zealously represent the child's best interests. Now, this is not available under Section 32A1-7.1 for youth attorneys. It is only available relief under 1-7 for GALs. Youth clients and adult clients can waive any of those conflicts. It is also interesting that there is no separate statutory section for the respondent attorney's duties. There's a YA section, a GAL section, a children's court attorney section, but no respondent attorneys section codified in the statute. Some other things that a guardian ad litem should do is definitely consult with the child to present the declared position of the child to the court. Obviously, when you have an infant or a toddler, it's difficult to get that child's declared position. So you can do things like the 4-month-old is always very smiley when having visits with the parents, and is also smiley at the home. Or the toddler seems to enjoy this game and obviously is very sad when leaving visits with parents and they start crying. So those are not declared positions expressed in words like you traditionally see, but that's still the child declaring its position. There are also specific duties and responsibilities outlined in 32A17 regarding investigating and determining best interests. There is also lots of information in that statute regarding protecting cultural needs. A GAL still has to follow the rules of professional conduct and the confidentiality of the Children's Code. And just like for the youth attorney in 32A410, there's also the zealous representation codified in statute of the GAL for the child's best interests. So here's some of the things outlined in the practice standards for how a guardian ad litem determines a child's best interests. Because again, it's hard to communicate with a 4-month-old or a 3-year-old. So you have to take through an objective evaluation, factors such as age and level of maturity of the child. So what I personally do, things that are in brackets on the slideshow are commentary that Twyla and I have that are not explicitly laid out in the practice standards or the statutes that we're setting. But when the practice standards say age and level of maturity, what I like to do, and this is how they practice in Arizona as well, is taking into consideration the child's expressed interests and to what extent you are going to honor those expressed interests is also part of best interests. And that would also need to take into account developmental capabilities of the child. So what I'm talking about here, for example, is I'm representing as a GAL a 10-year-old client. And that 10-year-old client tells me, I want to go back to daddy's because he lets me stay up all night and he lets me play video games all day. So while I'm going to tell the judge, this is what my kid is telling me, I'm not going to necessarily weigh that as heavily as the opinions of a child client who says, listen, I know dad used to do drugs, but I know that he's not anymore, and he's been really great during visits. He's been listening to all of my concerns, helping me with school. That's going to be a different reasoning that that child is expressing to me for wanting to return home. So I'm going to definitely consider that in their best interests, along with all of these other items. So sense of time, is the kiddo able to say, you know, recognize that they've been away from their parents for however long, or that such and such event happened whenever it happened, that sort of sense of time consideration. Culture and ethnicity, attachment to family members, this includes siblings, half-siblings, continuity and consistency in placement, as well as sense of belonging and identity. This is a great segue. I did have a question, but I was from the audience, but I was about to address this anyway. So I have had also I started out as a guardian ad litem for a group of siblings, and we'll get to sibling representation here in a second as well. I started out as guardian ad litem for a group of siblings. The oldest sibling happened to have severe developmental and intellectual disabilities, and that older sibling was the first one to turn 14. So under the rule, I was able to transition for that child's, from that child's guardian ad litem to the youth attorney when he turned 14. But I still did not think, because of his intellectual disabilities, that he was able to really assist in the representation, because it's difficult to be a youth attorney when you're supposed to follow a client's expressed interests if that client is not able to express their interests because of some disability. You see this the same as a respondent's attorney. If the client has developmental disabilities, mental health issues, or some other reason where under the rules of professional responsibility, they are not able to assist you in the representation, you can move to get a guardian ad litem also appointed for that individual. This guardian ad litem does not have the same duties as a guardian ad litem for a child under the age of 13 under the Children's Code. Guardian ad litem for someone with diminished capacity has different roles and goals, and that's really outlined more in the rules of professional responsibility. So I definitely have encountered that, and that's something that you might see. I do know that this is one of those things where you have to know your judge. You have to know their court, because there are some judges who will never appoint a guardian ad litem for an adult or youth client, and there's some that will. So you just have to make the argument and represent your client to the best of your ability. Moving on to that transition, as I was talking about, from guardian ad litem to youth attorney as the child ages, as well as representation of multiple siblings. So when the child turns 14, the GAL can continue as the youth attorney unless the child says they want a different youth attorney, the guardian ad litem requests to not be appointed as youth attorney for whatever reason, or the court determines at that time of the turning of the age 14 that a different attorney is appropriate. You have to read this one in conjunction with all of the other statutes regarding the youth attorney and guardian ad litem rules and roles. So in conjunction with 32A 410E, we have Rule 10313 that says one of the two things that you're going to file when your client turns 14. These are very important things, so that not only, because not all of the judges or respondents attorneys or CYFD personnel, immediately key on to, oh, the kid's birthday was this week, right? So filing this notice is a nice heads up, but it also provides a heads up to your role as the representative of this child has now changed. Or, hey, I can't be the youth attorney for whatever reason, so a youth attorney needs to be appointed as soon as possible so that the continuity of representation continues. Rule 10.3.1 has a huge amount of text regarding representation of multiple siblings. So I definitely think you should take a look at that rule itself and the conditions listed in the rule itself. The biggest part to take away from that is that a single attorney can serve as both youth attorney and guardian ad litem for a sibling group unless there is an actual real concurrent conflict of interest, which means direct adversity or a significant risk of material limitation in responsibilities. So they're very simple things. It is not just a conflict because you are one of them an expressed interest attorney and one a best interest attorney.
So communication itself, methods, styles, everybody has different methods and styles, but everybody, I think, has different ways of approaching and being flexible in the situation. When you're talking with your respondent or your youth attorney, yes, it is client-driven representation, but that doesn't mean that I'm forgiven from explaining to them why it's a bad idea or why it's a good idea or how we might approach it in a different method to make it more successful. You also have to take into consideration where the client is at when you're talking to them. And I don't mean physically so much as mentally, emotionally. A client who is dealing with active hallucinations, you're probably going to have to take some more time going over and breaking down and probably repeating yourself in different methods to try and get them to understand what is actually going on. And sometimes you're just going to have to deal with the fact that the client is going to continue to have their own reality of the situation. We most frequently see this, I think, among respondents when they have a ingrained belief that CYFD is taking their children to sell them or otherwise make a profit from the case. That can be a very hard viewpoint to work around with the client. And every client is kind of different on how you approach it. And I've had some clients where throughout the entirety of the case, throughout the entire TPR, we never could get beyond the ingrained belief that the client had regarding the authority of the court, the rationale of the court, the rationale of CYFD, the rationale of the government. So all I could do was present their positive aspects in the best way possible, and argue that their opinion of CYFD is not an impact upon their ability to parent their children. And I can't, of course, off the top of my head remember the case now, but there is a case that talks somewhat about the fact that mom doesn't have to like CYFD in order to successfully complete her plan and successfully get her child back. I bet Miss Liggett, who I think is on here, probably knows the case off the top of her head, so maybe she'll put it in the comments. Let's see. So as far as representation, consult with the client, meet in advance of hearings, statutory meetings, youth attorney also meets with foster parents, which includes, reviewing the court report with the client. Age appropriate, whether I'm GAL or youth attorney, I try to talk to them about what's going on in the case. The youth, of course, has the higher rights than the child who's in the GAL stage, but they deserve to know what's going on as age appropriate. And then once, of course, the child is 14, just like with my adult client, they get to know the down and dirty as much as they want to know about it. I have had youth tell me that I don't want to know what my parents are doing. I don't want to know what's going on in the case. I'm fine where I'm at, and the youth's opinion was quite honestly the parents were going to screw up anyhow, so they weren't going to worry about that, and they were going to fixate on them, work on themselves. But again, I still have to make the offer and let the client know that this is what I'm supposed to make sure you understand, and then handle it the way my client wants me to. Plea offers, obviously when I'm representing the respondent, I need to let them know what the department is discussing, share with them the pluses and minuses of it, and see what they want to do, because it's always going to be their decision whether we're going to have a trial, whether we're going to have a plea at adjudication, whether we're going to have a TPR trial, whether they want to explore relinquishment prior to, and the pluses and negatives of each choice in a way that the client can understand, though. So mental health, drug, trauma, other stressors, legalese. I sometimes really have to watch myself that I don't fall into archaic words that really nobody else uses in the common language. And I usually tell my clients straight up that I talk fast sometimes. Sometimes if I lose you, if I'm talking about something and you don't understand it, you can stop me. We can back up. Please interrupt me, because my goal is to make sure that you understand what's going on. And a good example is how we often fall into the habit of using initials, IJR. Most people aren't walking around using alphabet soup to talk. And as professionals, we fall into it. So we have to slow down, stop, and make sure the clients also know what we're talking about, because many times I've seen clients nod that they understand and agree with something, and then talking to them more to be like, they were just agreeing to be cooperative, not because they understood the down and dirty. So prior to us getting into that situation, I need to make sure my client has the best grasp of what's going on as is possible. Review the court orders with them, the consequences with them. And I lost track on the slide. I'm sorry, Shasta.
Typical considerations of parents' attorneys attending treatment team meetings.
Yes.
I'm actually going to skip ahead on the slide so that you can talk about that.
Yeah, so there is interesting aspects there that need to be addressed. Let's see if I can get to the right slide. Treatment team meetings, 16402, and representing a client, a lawyer will not communicate about the subject of the representation person. The lawyer is to be represented by a lawyer in the matter unless the lawyer has the consent of the other lawyer, is authorized to do so by a court order. As a GAF, I frequently, as youth, attend meetings about my children. Treatment team meetings are the biggest example of that. In a treatment team meeting, though, when I'm representing the child or the youth, how do I balance out my ethical duties when the parent is also present? I've had the situation arise more than once where a meeting was called for us to discuss the child's progress, get in there, and a parent, especially with video conferences, making it even more interesting, but get into the meeting and the parent wants to talk something about what's going on in their life. Their attorneys generally are not present at the treatment team meetings. I've had some treatment team meetings that respondent attorney absolutely refused me to participate. But the parents' attorney is frequently not there. I have an ethical duty, though, to remove myself from that situation. If a parent starts going off talking about themselves, the situation, if the department's, for example, not going to redirect the conversation, I should not be listening to it. It doesn't matter that I'm the GAL or the youth attorney. That person has representation. And I think, in my opinion, I have an ethical duty to speak up and say, their attorney's not present. I need to step from the room, and this isn't appropriate without their attorney present to protect their rights. I've had ICWA cases where the tribe wanted to start basically giving the parent the fifth degree, just questioning them. And again, speak up. Their attorney's not present. I'm going to remove myself from the room, but this is not appropriate. Parents, oftentimes when I do home visits, when the children are trial home visits, I've had to redirect them before because they obviously want to share with you how well things are going. And I notify respondent attorneys. I try very hard to email in advance or text in advance respondent attorneys to say, hey, I'm going to do a home visit. After the home visit, I try really hard to update the parent attorney as to, hey, I did the home visit. I was really impressed by this. If there was something I was concerned about, I typically tell the respondent attorney as well as the CYFD, hey, I had a concern about this. This needs to be looked into. What's being done about, for example, the broken window. There's a broken window on the house when I showed up to, do the home visit. No glass on the floor, no safety risk at that point in time, but this needs to be looked into, as opposed to either ignoring it or in some way questioning the parent about it, because again, the parent's represented and that's not my role, and that has nothing to do with my role at that time. That would permit me to break ethics and talk to the represented client about the broken window. Shasta, I know you wanted to pony off of that, so.
Yes, and I'm going to head back, if my slideshow will let me, to the Guardian. There we go. Also, I received a message from chat. Rebecca Liggett was on the meeting, but was not able to stay. So she did not hear your question, Twyla, and there is no magical case in
Bummer.
yeah, that's okay. Also a couple of questions, because I know several of you need to head out for another class at 1. The specific rule regarding diminished capacity for directed clients, that's rule 16.114. So the question that was posed is, an individual has as a youth attorney been encouraged by foster parents to request a GAL for a youth client because the foster parents didn't believe the youth was behaving safely. So under rule 16.114, when a client's capacity to make adequately considered decisions in connection with the representation is diminished, the lawyer shall still, as far as reasonably possible, maintain a normal client-lawyer relationship. Now, if that lawyer believes the client has diminished capacity such that they are at risk of substantial physical, financial, or other harm unless action is taken, and that client cannot adequately act in the client's own interest. And I think cannot is a much different word than refuses to. So I also do adult guardianship work, and the big question is adults, and in this case, youth, they have the full right to make stupid decisions. It's when that they don't recognize the impact of their decision that the diminished capacity part comes into play. And there's also a quick question about at which point I begin talking to a child about the transition to a youth attorney. When they're 12 or 13 and I'm their GAL, I start doing that conversation as soon as possible, because as the current slide talks about, one of your duties as a guardian ad litem is to describe that guardian ad litem's role. So while I'm talking to that 12, 13-year-old, I'm explaining guardian ad litem's role as a best interest. I'm going to listen to your position, I'm going to tell the court, but I'm your best interest attorney. Now, I say, when you hit 14, the world changes, and then I have to advocate for whatever you basically want me to advocate. So I start having that conversation with them pretty early and pretty frequently. And that's also the way that I like to justify to those younger clients, not justify, but explain why I'm not completely advocating for what it is that they want me to advocate to.
But I think it's also important to remember, though, that the child needs to know that they do have a right to express their opinion. It's just as a guardian ad litem, I'm not necessarily going to be cheering on that expressed opinion. And I'll tell them straight up, it's like, I understand that you're saying that you want to say, go live with your parent. But as your guardian ad litem, I also have to look at what's going on with what your parent's doing, how safe it is. And so I try to make sure that they understand I'm not just saying no to say no, but to make sure that they understand that I'm hearing them, and that I'll make sure that the court understands that expressed position. And how I say it sometimes is also important, because just because I can say something in the bluntest way possible doesn't necessarily mean it's the most useful way to state it.
Absolutely. And there is also, going back to the GAL thing, for diminished capacity clients, there is substantial commentary in Rule 16.114 that you can take a look at as well. So briefly on this side, this slide, just like the youth attorney wants to, is supposed to talk to foster parents, obviously the child's GAL is also supposed to talk to caregivers when doing that home visit and speaking with the client in a developmentally appropriate manner. Cultural relevancy is the term Twyla uses. I like to call it hipness, but hipness and cultural relevancy can also come greatly into play when speaking with youths and children, and also younger adult clients. My GAL kiddos, or my kiddos as I'm a GAL, their eyes just light up when I can talk Pokemon, speak to them, and know at least the original 150 Pokemon. So that is definitely something that I have bonded over with, and I know that Twyla also has a video game background, so we're able to create that bond with the younger clients, but then they are more likely to talk to us. Same thing when you go visit a kiddo in a 5-piece suit and a 3-piece suit, and stand there stiff and lean over them, they're not going to be as open with you with the things that are concerning them as if you wear jeans during your home visits and get in the floor and play dollhouse or tea party with them or what have you. So that's very important things to take into consideration. I don't want to belabor this too much, but there are statutes and rules and forms regarding children attending hearings. This is definitely one of those know your judges situations, because some judges, their version of a compelling reason is a lot different than another judge's version of a compelling reason or best interest consideration to either have children in court or not have children in court. Another very important thing to note is children coming to court to say hi to the judge is different than children coming to court and sitting through an entire hearing, which they might be 3 years old and not really able to sit still or wanting to sit still for an hour-long permanency hearing or what have you. Or it might be an adjudication or TPR trial discussing very sensitive information, which you as a GAL doesn't feel that it's in your kiddo's best interest to hear. Or the youth just doesn't want to come. Most judges will find it compelling if the youth just doesn't want to come. Most judges will find it as best interest or compelling if the kiddo is in school. So you really just have to know your judges, and you have to complete the form, depending on youth attorney or GAL, 15 days prior to a hearing. This is just another statute real quick, 32A 433B, because we're talking about confidentiality and what information should be provided to whom, when, and for what reason. So the attorneys have access to all of this provider information, but not everybody else is supposed to have access to it, okay? So if you're a GAL or a youth attorney and you're doing your home visits and speaking with foster parents, and the foster parent is like, hey, are the parents still testing dirty? Don't tell them that. That is a breach of confidentiality, except to the extent that it's to meet the needs of the child. So if the foster parent says something like, I picked up the baby from the visit and the baby smells like weed, then you can talk to the foster parents about that concern and relay only to what information you need. Or if during the time of COVID right now, we'll see how well this recording ages, discussing virtual visits, but it might be a conversation you need to have with the foster parents if the family on the other side of the screen is falling asleep during the visits. But you should not be telling, regardless, you shouldn't be telling the foster parent the results of the parent's drug test. You should not be telling the foster parent the results of the parent's psychological evaluation. Those things, there's zero need for you to relay that information, and it's a breach of confidentiality. Some things that I will do is for like a child's psychological evaluation, just the diagnostic page, or the neuropsych for the child, just the diagnostic page that says, Dr. XYZ says this kid has a language delay. I'll give just that page to the school for IEP work, individualized education plan assessment, but you don't need to give the entire psychological or neuropsychological, as those professionals are basically recounting what's in the affidavit or what they learned from a parent's psychological evaluation. Just that diagnostic page would be allowable to be provided to another provider. And there's a whole bunch of, go ahead, Tyler.
I was just gonna say, and I know that, yes, parents might be at the hearing and they might hear all the drug results and everything else at the hearing. But again, that's the court's opinion, the court's right to, have all that information out there versus me assuming or stepping on confidentiality and just having a gossip session with the foster parents. And unfortunately, some foster parents seem to think that's what we should be having. I mean, foster parents also sometimes seem to have a hard time understanding I'm not their attorney. I'm the child's attorney. I'm there to visit the child, share information, get information from the foster parent, but I'm not there to advise the foster parent on what they should be doing.
Exactly. So it is about 1 o'clock. Just a reminder, this PowerPoint and the recording of this presentation will be available. I will send the PowerPoint out to everyone who signed up just immediately after this meeting. The recording will be accessible on the State Bar of New Mexico website for the Children's Law section, and perhaps on the Corinne Wolf website. I need to talk to Kristen a little bit more on that. I think I have answered all of the questions except for the last one. How do you keep your own cultural and experiential biases out of your GAL best interest determinations? I could do a whole hour-long presentation. I have done a whole hour-long presentation on cultural competency, not in this context, but it's definitely, something you have to be aware of. So when we're talking about recognizing other people's cultural considerations, the very first step in that is reflecting what your own cultural considerations are. So what biases, what microaggressions, what thoughts and feelings do you have? You have to really be self-reflective of that. And one of the ways that you can catch yourself in order to begin that self-reflection process is if you find yourself making a judgment call think about why it is that you're making that judgment call, right? And that's how you can open up yourself and your mindset to really make sure that you are not letting your own biases overrule that. The Harvard implicit bias test, if you Google that, Harvard, like the fancy university, if you Google that, they have a ton of implicit bias tests as well, from skin color to sexual orientation to gender identity, body size and weight. They have, I think there's like more than a dozen different implicit bias tests. So that is also something that you can use to determine your own implicit bias. And if anyone had to go at 1 o'clock, feel free. We will, like I said, post this recording. I think, and if you have any other questions, feel free to pop them in the chat. Twyla and I can hang on for a little bit longer to finish this last slide. And any other pop-up questions, or at least I can. I guess I shouldn't talk to whether Twyla is actually able to stay past 1, but I can.
And on the GAL bias thing, I mean, GAL youth attorney, even respondent attorney, I mean, oftentimes you do have to look and set aside your personal feelings about something. When I'm doing a home visit, on trial home visit, I may not completely think that the house is as fit as perhaps in my experience it should be, but that's not what I'm there for. Is the child safe? If the child needs being met, it doesn't really matter whether or not it's good housekeeping, decorated, beautiful. A lot of our families do come from different socioeconomic backgrounds and different opinions and different abilities to furnish a house. Furnish, not furnace. I did a recent home visit where the parents were freaking out that there was, some piles of clean laundry. Video visit, but recent visit. And it's just like, not gonna have an opinion about you're doing laundry. Piles happen. And right now, I don't even want to talk about my piles of dirty laundry that need to be done. But again, if I go in there with the lens of everything's supposed to be perfect, well, that's not really the goal. Perfect is not the goal. Providing adequate parenting is what we're looking for. Perfection's really a bias.
Absolutely. And just a reminder, 32A17 does allow for removal of a guardian ad litem on the grounds that person is unwilling or unable to zealously represent the child's best interest. So if there is a bias that is just not being able to be resolved, then there is a removal process for guardian ad litems who are not able to represent best interest because of that bias. Time management. The practice standards, like we already said, the practice standards for all 3 roles says you're supposed to be attending these treatment team meetings, these school meetings, and other staff meetings. But as we've already talked about, there are issues with Rule 16402. There's also reticence on the parts of schools and therapists to allow particularly respondents' attorneys to be involved in these things. So realistically, you are more likely to actually be able to participate in these things as a GAL or a youth attorney, which means that there's more time on your books of participating in these meetings when you're in one of those 2 roles. Whether or not you attend the meetings, you should definitely request written documentation, request those IEPs, request those therapy notes, request those treatment team meeting progress reports. Everybody who is an attorney in these cases, per the Supreme Court form orders for all of the hearings, have access to all records and reports relating to investigation, treatment, and/or education. So that's parties and attorneys. I did have a conversation yesterday with a child's therapist, however, and they would like me to have the conversation with the respondent's attorney about to what extent the respondent's attorney is willing to limit the mother's access to the therapeutic records of the child So that's a conversation I'm going to have, but that doesn't change the fact that the parent does have the right to those. Office hours is a big thing. Twyla, I know that you have a different phone setup than I do. You want to talk about that?
Yeah, as far as just in my practice, we have a live person that we try to have in COVID, of course, makes everything interesting, in the office answering during regular business hours. During after hours, since most of our work here in Albuquerque, at least as respondent attorney, there's a voicemail system. I do not, as a typical rule, give my adult clients my cell phone. I try to get them to understand that we will handle things during regular office hours. My children and my foster parents are a whole different ballgame. They do have my cell, and I've ended up handling calls, fairly late at night when a child needed to talk to me. I've handled with some of my teen youth text messages at weird times of the week and the day and the hour because they reached out to me. But there has to be a balance, and everybody has to find it. But at least as far as my youth and my children go, office hours don't usually apply. And as a youth attorney and a JL, I see in the long run a lot more time commitment as opposed to the RA, if only because of the home visits, treatment team meetings, the school meetings that all require sometimes travel, flexibility of schedule, and usually are not going to fit within my regular work day.
Right, it's really, and while you can totally do a visit of a child at the school to see how they're doing at school, balancing the consideration that then you're taking them out of class, you really do have to do visits at the placement. So that's going to be after school. It's going to be, I've done visits at 7 a.m. before school. I don't like doing that, but I've done it before. I'm not a morning person. But evenings, weekends, that's when you're gonna have to do your home visits. It's just the fact of the reality. I have two cell phones. I have my personal cell phone and I have my work cell phone. My paralegal also has an office cell phone, so she can also text with people. I am a big texter, but that might be a symptom of my generation. I have, unlike Twyla, the foster parents, well, I don't have a hardline office phone, so everybody technically has my cell number. But yeah, office hours for me don't really apply for my kiddo clients. And I'm getting better with forcing them to apply to my respondents clients. I recently taught a client that I will not be responding to you outside of Monday through Friday, 9 to 5 p.m. because he would be contacting me at 8 p.m. wanting immediate information that was not really an emergency. So you have to do those work-life balance rules to set for yourself as well. And you have to, I mean, you don't have to, but you basically, reality-wise, have to coordinate the home visits with the foster parents when the kiddos are not on trial home visit. For coordinating visits when your child clients are on trial home visit, again, you always have to remember Rule 16402. And this gets into collegiality because you have to, as a GAL or a youth attorney, be on those collegial terms with the respondents attorneys. Twyla was already mentioning this. She will, like she said, do a home visit and email the respondents attorneys real quick. This is what they saw. But you also, what I usually do when we have the transition planning calendar to move the kiddos back to a trial home visit, I say right then, while all of the attorneys, all of the parents are in the room and the facilitator is putting the notes in the FCM layout, I say, don't forget, I still have the responsibility and the right to visit my clients while they are on trial home visit. So I want to have the discussion right now. If there's any concerns, if there's any questions that the respondent's attorney has, that the respondent has about what those boundaries are and what sorts of things we're allowed to talk about, and the expectation of, if you are the parent and the kids are on trial home visit, like I still expect you to tell me when my kiddo has an IEP meeting, for example. So I like to have that conversation at the trial home visit calendar meeting. Most of the time, there's a good relationship and rapport built between the respondent's attorney and, at this point, the GAL and the parents, so that they're comfortable. But I have had respondents insist that their attorney be present for me when I go do a home visit, and that's fine. That's within their right, you know. And then you have to go back to the collegiality part and make sure that you're able to coordinate a home visit with that other super busy attorney.
And as a respondent attorney, I sometimes have coordinated with the youth attorney or the GAL to be present for the home visit, if only to make sure that the, you know, interactions were more comfortable, because sometimes there is a lot of angst.
Tension.
Tension, there we go. Tension's a much better word. So sometimes you have to think outside the box, but as a general rule, if the kiddos are on a home visit, my parents going to, you know, be having the GAL youth attorney come by. So I want to have talked to them in advance about what's appropriate, what's not appropriate. And sometimes the best of plans, it doesn't matter. Some clients are still going to try to share everything under the sun with anybody who walks in the door. As the GAL youth attorney, if that happens, all I can do is try to mitigate and then update their attorney that, hey, your client kept going on about this. I redirected them that they need to talk to you. FYI.
Exactly. Because Rule 16402 specifically says the lawyer shall not communicate about the subject of the representation with a represented person. So technically, you can talk to the parent about your kids' services, but it's when the parents start talking about their own services that it gets really hairy. One other quick tip, and I don't believe there's any additional questions, but one other quick tip that I have, because I do work across so many counties, is I literally have a map in my office with little Post-it flags that says where all of my kids are placed at any given time. So I try to consolidate home visits all in one afternoon. So I live in Albuquerque, but I have lots and lots of clients placed in Los Lunas on either side of the river. So I will try to do one side of the river in a single afternoon and try to coordinate that. Or if I have kiddos placed in Mountain Air and Socorro, so I will try to spend a Saturday morning doing my Mountain Air home visits, maybe swing along back and do my estancia visits that afternoon and spend a whole Saturday doing home visits. Or the day after Christmas, I've done that in the snow. So if you do have, as a GAL or YA, just a ton of kiddos all over the place, or this is even applicable to like South Valley and Rio Rancho. You don't want to have a 3:30 South Valley home visit in Albuquerque and then try to get to Rio Rancho for a 5 o'clock, because it's not going to happen. It's going to be impossible. So we got a couple more comments. Oh, just another thing. It might also be helpful. I try to do this to an extent. It's also helpful to keep track of past placements for kiddos, because usually those kids had quite a bit of a relationship or a bond with those prior foster homes, particularly if maybe they were originally in a non-relative and then got moved to a relative. So keeping that contact information is useful in case later the kid contacts you and is like, hey, I would really like to get back in touch with so-and-so who was my placement a long time ago. So you can facilitate that to the extent the foster parent is willing. That foster parent might also have background or historical information about the kid that perhaps did not get into a CYFD report or documentation in the CYFD file. Okay, some more questions. If the judge agrees to appoint a GAL for a diminished capacity respondent, and the GAL moves the court for a competency evaluation for that respondent, who might that evaluation be arranged? So that's probably, and I don't recognize the name of the person who asked that question. So I'm assuming they are in a county that I don't practice in. So that would be a question probably to ask the department, because the department in your county will have a list of providers that they will be able to pay for the evaluation. So that's a good starting point, because basically at that point, the quote unquote competency evaluation, it would probably be more in the form of like a neuropsychological evaluation, depending on the thing that is creating the alleged diminished capacity. But regardless, a provider should be able to be paid either through Medicaid or CYFD. But the department should have a list of local providers for that. Do you have anything to add on that, Twyla?
If the department is unhelpful, the court for criminal cases usually has an attorney that is the selected attorney to do evaluations for that area. So it might be possible to get the funds approved via AOC if CYFD isn't.
Mm-hmm. You can also, sorry, go ahead.
I was just going to say, although then again, the court in theory would probably order the department to assist in getting that evaluation. But there's always the one-off situations where maybe you have to think outside the box.
Some other suggestions I have in the comments here is that a general competency exam is different than a forensic competency exam because these are not criminal matters. However, your local criminal defense attorneys might also be able to provide you a list of names that of people who do this evaluation. A follow-up question from the same individual, there was apparently the court was not sure what authority the court had to order the evaluation. So I think that's where you get it added as part of the CYFD treatment plan, because not only would it be a competency evaluation to determine whether or not, or some sort of evaluation to determine whether or not the client has diminished capacity and requires a GAL. It's also, that information is going to be super important for the department to know, because there might be an ADA, Americans with Disabilities Act claim or accommodations that need to be made. The department is going to need to know, like, is this person not able to read? In which case everything needs to be presented to them verbally, or vice versa. Does this person have a language computation disorder? In which case everything needs to be in writing. So that is all very important information that should just be added to the CYFD treatment plan, which then gives the judge the authority to order the evaluation. Also, the Corinne Wolf Center and Kristen Conley, who's provided much of the amazing commentary that I am relaying to y'all. Her contact information is on the Corinne Wolf website if you don't already have it. She is always a great person to ask questions of. There's also a forms bank for representing both children and parents. That forms bank is ongoing. So it's different from like the actual official Supreme Court forms. It's more like, which are also in the bank, I believe, but it's also templates that don't otherwise have official Supreme Court forms. And I think that there was one other question. Oh, social distancing. I'm loving video visits. Like, Twyla and I were discussing this yesterday in preparation for this presentation. I have started doing video visits via Zoom or Google Duo or Skype. I don't have an iPhone, so I can't use FaceTime, but very similar things. I've been doing that to do visits with my clients. Even the cute, adorable babies who can't talk to me, I still get to see them be cute and adorable, and the foster parents show me the room and show me around the house. Particularly for clients who I've already visited them in the placement and I'm familiar with the placement. It's a little bit different if you get a brand new case or a placement change and you're not familiar with the home. But I think, I mean, if social distancing ends, which I hope it does, and I hope, you know, the pandemic ends and all of that. But I would probably still do virtual visits in addition to my in-person visits, particularly since my placements are across so many counties and there's a lot of travel time. I like to do my visits about every 12 weeks, not just immediately before a hearing. And then I keep in contact with the foster parents via text message and phone calls, but this whole virtual visit capability makes it easier to do more frequent visits. I can do my in-person visits, and then I can do monthly video check-ins. So I think that that is a great positive takeaway that this whole disaster has created for us. Tyler? Anything else to add?
Summed it up pretty much. I mean, the social distancing, the video visits, it's hard, especially with nonverbal clients, but there's still ways to interact and engage, and not being a talking head necessarily, which has been really hard to hold still for this thing. I'm usually more animated, but you can generally still engage with your children even through the social distancing. And with my respondents who can, I've been trying to do the Zoom, et cetera, with them, because it really does, I think, help to see the face, but not all of the clients have that capability. Not all the foster parents have that capability. And in some of my cases, or the bandwidth, because they're in pretty much null zones. So a phone call may be the best we can do.
I think Twyla and I could probably spend another hour talking about how the pandemic has affected the way we practice. But if this goes on much longer, maybe we'll just do a whole new webinar on pandemic. But we are out of slides and out of questions, so I will make sure this gets all posted. Thank you all so much for tuning in with us today.
Thank you.
I can figure out how to stop it.
Yeah.
Stop sharing. Okay, there we go. And now